In this video and the next few videos, we are going to go in deep with the protections in your private association, in the private domain. A lot of people keep asking, we've done, but it's going to go deeper. And the document that I'm referencing is written by David Edwards. I will absolutely link it below so that you can reference, you can look up stuff for yourself, but let's dig in and find out why the association is so protective and what that means to you in your private medical practice, your private healing practice, your private ministry. So our association is protected by the 1st, the 5th, the 9th, the 10th, and the 14th Amendments. Let's cover those really quickly. Again, short version, please look these up for yourself. First Amendment, this protects our free speech, our free religion, freedom of the press, which does not mean, the founders did not mean that this just meant that you could go wild in the press and advocate for evil and destruction of society, which we've noticed that is happening, but that's not what they meant with freedom of the press. We have freedom of assembly and petition. 5th Amendment, due process. This means that the courts have to respect all rights owed to the people, and it's constitutional governance tied to the 14th Amendment. I just love how these all go together when you start to really study them. 9th Amendment, non-enumeration. Numeration is numbers, right? One after the other. Non-enumeration rights are not limited to those named in the Constitution. Additional fundamental rights are protected from government infringement, aka natural law equals God's law. The 10th Amendment, rights are reserved to the states and the people, limiting government. And then the 14th Amendment, this is citizenship rights, equal protection. No, underline, no state shall abridge the privileges or immunities of a citizen of the United States, nor deprive any person of liberty or property without that due process that we spoke about in the 5th Amendment. So your private association is, if it's properly formed, this means that your association is outside the jurisdiction and the authority of the public, the state, the local, federal authorities and agencies. This right, it's not absolute, but unless your association is practicing substantive evil with a clear and present danger, then you are protected. In other words, there shouldn't be any concern of subject matter or what you're doing in your practice, that it shouldn't be subject to an injunction or any criminal charges, or of practicing medicine without a license by law enforcement when practicing your profession within your properly formed private health association or healing ministry. But we're going to do a little more digging to really get how this all came about and why you are protected. So we've got to look at two different types of crimes. So we have the mala in se crime, and this is the one that we all really know morally with a moral compass that you're not supposed to be doing. It is evil, murder, robbery, rape, doing things with children, sacrificing, all of these things that are inherently evil. That's a mala in se crime. We can kind of set it aside a little bit while we grasp the mala prohibita crime. And what that means is it's not a crime in itself. It's only a crime because a legislation or a federal Congress makes it a crime for public welfare. So let's go real life. Back in the day, chiropractors, they're healing people. And then the AMA, American Medical Association, medical doctors didn't like that chiropractors were healing people. So they made it a crime because chiropractors were practicing medicine without a license. We had to put a licensing structure in place so that then chiropractors could now be subject to these laws and not be criminals for practicing without a license. There's a licensing statute. A person who conducts that profession without a license could be charged with a felony criminal offense for practicing without the license. Now, there's some case law about the private domain in the First Amendment Legal Membership Association. I will let you go look at this. It's the case of the NAACP versus Button. They did find that the association was protected by the First and the 14th Amendments. When we look at these different crimes, a private mode or domain is protected and a different domain than the public domain. It's a mala prohibita felony criminal act in the public domain. It became legally protected in the private or private association. Back to our evil mala in se crime, that's not protected anywhere. Okay, murder is murder, whether it's in the public or the private, to be simplistic. So again, you're doing good unless your association is practicing substantive evil. In the document, there is some more case law. I'll let you again do your research, look this up, and wrap your heads around why the case law is upheld. Liking this content, if you like going deeper, be sure and like, subscribe, and share this channel. And I sure appreciate you being here. Okay, let's go deeper with some background of this. Now, the Constitution doesn't explicitly define the private domain, but the Supreme Court has definitely acknowledged that certain implicit rights, such as association, privacy, and presumed innocence, share these constitutional protections in common with the explicit guarantees, such as our free speech, the right to assemble, and the right of religion and privacy. Specifically, the Supreme Court has described the right to associate as inseparable from the right to free speech. And we go back to that beautiful picture sitting around the dinner table, sitting around the living room, sitting around the fire, and we're as a family or friends, and we are able to get together and we're able to talk about whatever we want to talk about, and it remains private. Nobody can tell us what to say or who can come there. The right of association under the Constitution then began to be heavily litigated in the 1950s and 1960s as people were realizing that their rights were being slowly infringed upon and began to establish private associations. And cases did go to court and they were upheld in favor of the association. And then teaching us civics and our rights, freedoms, and liberties. So here we are. Time for us to learn again. In general, members of the private association do not fall under the jurisdiction of local, state, and federal governments and corresponding laws and regulations unless we go back to there's evidence of that substantive evil. So if we want to go real simple, example of the right to associate to avoid local laws is the drinking club. In Texas, there are many counties that are dry counties. So the use of alcohol and drinking is prohibited. But since drinking alcohol is neither illegal, nor has it been deemed counter to society's general interest, interesting in itself, particularly in the realm of the First and 14th Amendment. If there is a private membership association, then alcohol can be served by the member, the founder of that club, to the members of the club. Now we look again back at our and say if a murder is committed inside that private club, they're not going to be protected. Murder is murder. Doesn't matter where it happens. Same as if one of the members is drinking, leaves, and kills somebody in an accident on a public road, not going to protect them. It's important to note that the right to association is not limited to these social or political activities. Again, so we get to have our own private membership associations, our health associations, and our healing ministries, because we're contracting under our rights, under our due process of the 5th and the 14th Amendments, and states can't pass laws that impair the obligation of a contract. So contracts are pretty cool. All right. In conclusion, under the 1st, 5th, and 14th Amendments, we are guaranteed our due process and our liberties in our private associations and our assembly, our get-togethers. We will see you in the next video to go deeper.